What happens if you're 20 years into a contract for deed and all of a sudden someone dies? What happens next with the property subject to the contract for deed and whose rights are impacted? Watch this video to learn more. Hi, I'm Jason Wagner, the Farm Lawyer. I work with family farmers every single day to help them pass the farm on to the next generation. At my law firm, Wagner Ayler, we've been doing it for over 50 years. Today we're talking about contract for deeds. Contract for deeds are still very common in farm succession planning, and it's a good way to pass on land. A lot of times people are thinking, hey, I don't want to have a big tax hit when I sell this property. Maybe I paid, $1,500 an acre. Maybe I paid $500 an acre for this property, and now I'm selling it for significantly more. Even if you're selling it at a discount, right? Even if you're selling it at $5,000 an acre, you could still have some pretty significant capital gains there. So we want to sell it on a contract for deed. It helps us spread out that tax impact because we're only paying tax on the dollars that we receive when we receive it. If we spread it out over 20 years or 30 years, you're going to be paying tax all of that way, but you're not getting that big tax bite in year one. That's one way to soften the tax impact. I have other videos on here about share remainder trusts and 1031 exchanges, where we also talk about ways to soften the tax impact. But today we're focusing on contract for deeds. Now, if you're the buyer on a contract for deed, it also might be a really good deal. Maybe the down payment requirements aren't as strict as, say, a bank would require. The interest rate might be lower. So, it can be a good deal. It can get you into a property a lot quicker and a lot cheaper than, say, if you had to use a bank loan and buy it traditionally. But what happens if somebody dies? Okay, this is critically important. If you're the seller on a contract for deed, you still have an ownership interest in that property. It's a contract for deed, not a deed. So you're writing a contract that says, hey, at some point in the future, when you, buyer, have paid off this property under the terms of the contract, I will then give you the deed. Well, they can't give you a deed if they die now, can they? So what happens next? Well, this is where estate planning becomes so critically important. If that seller owns it with their spouse, maybe as a joint tenant, that joint tenant can take over. Now they own the contract. That's, pretty simple, seamless. We didn't lose a lot of sleep over that. But what if they're a single person? Or what if they're a widow and then they die? What happens? Do they have a will? Do they have a trust? These are things we need to know. So if they don't have a trust, that contract is going to go to probate. That contract for deed is going to be subject to probate. So now we've got to get the court process started. We've got to get somebody appointed to act. And then we have to basically, now we've got this executor, this personal representative, they can continue accepting payments. And if you've paid it off, they can give you a deed. This is something I've seen, all the time. People often forget, and it's 20 years, I get it, they forget that this is a two-step process. Enter the contract, satisfy the contract, and get your deed. These are two separate steps, and they might happen 20 or 30 years apart from each other. So we've gotten to that second step. You've paid off the contract for deed. Well, you're not done. The county records don't show that you own that property. They show that you have a right to buy that property. So pay it off, then get your deed. But if the person who sold it to you is dead, how are you going to get a deed from them? So we just talked about it. Maybe there's a joint tenant. Maybe they had to go through probate. I've had situations where, they come in and say, we're ready to satisfy this contract for deed. And we find out, well, one of the sellers actually died. they died maybe 10 years ago. Well, then we have to do a process similar to probate. It's a little bit quicker. It's called a decree of descent. But now that we've got to go track down, where did that property go? Did it go to their spouse? Did it go to their kids? Did it go to their first cousins and nephews and nieces? We need to know who's in charge of this estate. Where do we make the payments? Who gets the funds? And how do I get that deed? Now, a really simple trick that I recommend anytime I'm working with a seller on a contract for deed. Let's just not mess with all that. Set up a trust, okay? A revocable trust where you can change it, update it, say where you want the payments to go. But then the trust becomes the owner of your seller's interest in the contract for deed. The trust owns that interest. The trust can give us a deed when it's paid off. We don't need to go track down who's responsible for probate. Where does it go? The trustee is responsible for that. This is a really seamless way to make sure that we don't have things fall through the cracks and don't create bigger legal bills in the future for what we thought was a pretty straightforward process. So I'm going to establish my trust. That trust then is going to own the land. That trust then is going to enter into a contract for deed with my buyer. And then when that buyer pays it off, the trust will give them a deed. Does that mean that my trust needs to file a tax return? No. The trust is it's a revocable trust. The trust that follows your social security number. But if you already sold it on a contract for deed, don't worry. You can do this exact same thing. We will establish the trust after the contract for deed. Then we'll assign your interest as a seller to your trust. Same thing. We get the same result. We've just done it a little bit out of order. And that happens all the time too. I'll have clients come in and we always want them to bring in their property tax statements so that we have a thorough understanding of all the land they own. But usually they don't bring in those property tax statements for the land they sold on contract for deed. So we have to ask about that too. Have you sold any land on contract for deed? If you did, we want to grab onto that. We want to put that in your trust. We want to make things smooth and easy for you and the next generation and your buyer, so we can get that into the trust. One other important thing to remember as the seller, you did not pay deed tax when you sold the property. In my part of Minnesota, it's pretty standard that the seller pays the deed tax, which is based off of the sale price. But when you don't have a transfer of the deed until many years in the future, you also defer that deed tax into the future. So that can sometimes come up as a surprise for people. Why do I have this thousands of dollar state deed tax bill? I don't have any more money. It's all paid off. Well, yeah, because you didn't pay it 20 years ago, you've got to pay it now. And that's true whether it goes through joint tenancy or probate or trust. Somebody's got to pay that state deed tax so we can get that deed recorded for the buyer. Now, if you don't want to pay that state deed tax, you've got to write that into the contract for deed. Okay, good. So I'm the buyer. I see that my seller's got this in a trust. That should give you some peace of mind. But what if you yourself die as the buyer? Just like this with the seller, it's important to know where your rights are. Do you have the ability to transfer this property in the event of your death? We have to be careful of that. Do you own it as joint tenants with your spouse? Do you want to? If you don't already, potentially we can update that and have it be owned as joint tenants. Because it's a contract for deed, the most critical aspect, those payments have to keep getting made no matter what. If you're not living as the buyer, whoever inherits that contract from you has to keep making those payments. If they don't make those payments, the seller can cancel the contract. So again, do we want this to have to go through probate? Multi-months long process that's going to cost us more money and take more time in order to be able to protect this contract? Absolutely not. You as the buyer, you can also set up a trust. You can have your buyer's interest in that contract owned by your trust. So again, If you die or become incapacitated, we don't miss a beat. Somebody steps in, acts as trustee, continues making payments as normal. If you're making monthly payments, boom, right there, that's all going to happen within those 30 days. Go to probate, might take 3 months, 6 months, 9 months before we've got somebody appointed and we've got everything kind of settled out. So the big thing to remember here is the contract for deed is a relationship where the buyer and the seller both have an interest in this property for a period of time. So both of them need to protect that interest. We like to do that through the trust in the estate plan to make sure that we don't have a misstep later on if somebody dies or becomes incapacitated. We want to make sure this is a good result, not only at the front end, but also at the back end. In my office, we handle this from beginning to end. We will prepare the contract for deed, we'll do the title exam, we'll do the closing, we'll set up the trust, have that contract be owned by the trust, and in the event somebody dies, we'll help administer that. We'll get the trustee rolling with it so they've got the ability to step in and fulfill the contract. If this is something you're interested in, contract for deeds are still a good way to transfer farmland. Give us a call, 507-288-5567. Check out farmlawyer.com. Subscribe to my YouTube channel and like us on Facebook.